think it's important to understand some key aspects of the California APA process. APA, of course, is the Administrative Procedure Act, and California's APA is patterned after the federal APA and similar to those in the other 49 states. The purpose of the APA is to set forth the procedures by which our state executive branch agencies and departments are required to follow in order to adopt regular or emergency regulations. The main goals of the state and the federal APA are to ensure, for purposes of a proposed rulemaking, a notice to the public and an opportunity to be heard. Now, in that vein, there are a few items for those who participate in the rulemaking process of these state agencies and departments that I think you should be aware of. Remember that the defined purpose of a regulation pursuant to the APA found in our California Government Code is to implement, interpret, and make specific a statute. So for those who submit written and or verbal comments on proposed regulations to an agency or department, you should describe how a proposed regulation accomplishes one or more of these purposes if you support the rulemaking, or why the regulation does not accomplish them if you oppose the particular rulemaking. Now, the California APA provides 6 statutory standards of review that California's Office of Administrative Law, OAL, is required to use when reviewing any proposed regulations by those state agencies and departments. By the way, there are just over 200 of these agencies, departments, boards, commissions, and bureaus in the state executive branch. Now, the role of OAL is to ensure that the state agency has abided by the APA procedural requirements when that agency adopts a regulation. Now, among those 6 standards of review is clarity, so the clarity statement. And clarity is one of the main reasons that the Office of Administrative Law, again, OAL, rejects a regulation. And this is usually due to ambiguous or undefined terms that are used in the regulation. So if a proposed regulation that you're commenting on is lacking in clarity, that may be your best avenue for success in thwarting the adoption of the proposed regulation. The lack of necessity is another of the 6 standards of review, and is also the second most common reason for OAL to reject a proposed regulation. Basically, under this statutory standard of review, OAL is looking at some issues such as, has the regulatory agency distinguished between what is called the what and the why? The what is, what does the regulation do? The why is the necessity, the need for it. And it's this why aspect that's often not done sufficiently by the state agency that's adopting the regulation, and that according to OAL. In other words, the agency sometimes does not provide an adequate showing of why the proposed regulation is actually necessary. The agency usually does a good job in explaining the what, i.e., what the regulation is proposing to do, but they don't always do such a great job in explaining the why that regulation is necessary. Now, in my mind, necessity is probably the easiest standard to comply with, even though there are a number of rejected regulations every year by the Office of Administrative Law utilizing that standard of review. Practitioners should, and those who appear regularly before agencies and departments of California's executive branch, I think should also appreciate the difference between the authority standard and the consistency standard, and why these 2 standards are often misplaced or mislabeled by people who provide written or verbal comments on proposed regulations. Now, some who criticize an agency's rulemaking, they argue the agency doesn't have the authority to adopt this regulation. But in my mind, the authority standard is not the right one to utilize. Instead, the authority standard is pretty easy to determine because it's whether the agency has general or specific to adopt the regulation being proposed. And frankly, almost all state agencies have at least explicit authority to adopt proposed regulations. In fact, most agencies have general rulemaking authority, while other agencies get perhaps a specific grant of rulemaking authority. You might see, for example, in a statute that the department shall adopt regulations or may adopt regulations to implement this section or this chapter, for example. So in addition to general or specific rulemaking, some executive branch agencies have mandatory rulemaking and others have discretionary, the shall versus the may in the underlying statute. But oftentimes persons confuse these two statutory standards of review because when one argues that the agency does not have authority, it's likely not that the agency doesn't have the legal or statutory authority to adopt the regulation, because almost all of them do. Instead, what people are basically arguing, and what they should argue, is that the underlying statute that the agency is trying to, remember, implement, interpret, or make specific is being improperly expanded or narrowed. And therefore, the proposed regulation is actually lacking consistency, one of those 6 statutory standards of review. So it's lacking, the proposed regulation is lacking consistency with the underlying statute as opposed to being done without authority. So regulatory lobbyists and practitioners should actually utilize the consistency standard when they're opposing a proposed rulemaking and they're arguing that the proposed regulation is actually inconsistent with the statute, rather than making the incorrect legal claim that the agency lacks authority to adopt the proposed regulation. Also, there appears to be confusion about whether separate comments can be submitted to OAL after the conclusion of the agency rulemaking. The answer is no, because OAL does not have authority to consider submissions made outside of the rulemaking file. Specifically, the APA in Government Code Section 11349.1A, in reviewing regulations, OAL is required to restrict its review to the regulation and the record of the rulemaking proceeding. So accordingly, OAL is prohibited from considering any comments submitted to it directly concerning proposed non-emergency regulations. Now, Code of California Regulations Title 1, Section 55A specifically sets forth this prohibition on the OAL considering comments that are submitted directly to them by the public when OAL is reviewing a regular or non-emergency regulation and any certificate of compliance regulatory filings. This means that OAL only accepts comments made to them on emergency rulemaking actions, and those comments have to be submitted within the open comment period. So if you have concerns about a proposed rulemaking from an executive branch agency or department, you have to participate in the formal regular rulemaking process and submit oral or written comments to the rulemaking entity rather than directly to the Office of Administrative Law, since OAL can only consider the comments that have been submitted as part of the formal rulemaking process.